Hello, everyone. My name is Carlos Vasquez. I'm the Associate Dean for Graduate and International Programs here at Georgetown University Law Center, and it's my pleasure to welcome you to today's event. This is the fourth in our series of comparative constitutional law conversations, comparing the role of the highest courts in the world's two largest democracies, India and the United States. Both the United States and India have an independent judiciary, and their Supreme Courts are among the strongest in the world. This conversation series is a collaboration between the Georgetown University Law Center and the Society for Democratic Rights, an organization that was started by two Georgetown Law alums in New Delhi, Vibha Datta Makija and Kashish Aneja. It is now my pleasure to introduce the esteemed guests today. First, Georgetown Law is extremely honored to welcome the Chief Justice of India, the Honorable Mr. Sanjeev Khanna. Chief Justice Khanna is the 51st Chief Justice of India since the establishment of the Indian Supreme Court in 1951. He was elevated as a judge of the Supreme Court of India in January of 2019. In this capacity, he has authored several landmark rulings and served on multiple constitutional benches at the Supreme Court. His judgments consistently underscore the primacy of personal liberty, robust democratic participation, and individual autonomy. Known for his meticulous preparation, Justice Khanna's judicial approach has been characterized by a pragmatic view of dispute resolution and efficacious use of judicial time. In addition to his judicial responsibilities, he is the executive chairman of the National Legal Services Authority and serves on the governing council of the National Judicial Academy in Bhopal. Under his stewardship, the National Legal Services Authority has fostered an approach that prioritizes direct community engagement and strengthening access to justice at the grassroots. Chief Justice Khanna's judicial career began with his appointment as an additional judge of the Delhi High Court in 2005, where he was later made a permanent judge. As a High Court judge, he was at the helm of several key institutions, such as the Delhi Judicial Academy, the Delhi International Arbitration Center, and the District Court Mediation Centers. Across 4 decades of exemplary legal service, Chief Justice Khanna's trajectory spans both private practice and judicial office. From simple beginnings in the district courts at the Tis Hazari complex in Delhi, to subsequently expanding his practice to the Delhi High Court and numerous tribunals, Chief Justice Khanna built his expertise in constitutional law, taxation, arbitration, and commercial litigation. As per the Indian constitutional requirement of retiring at the age of 65, Chief Justice Khanna is due to retire on the 13th of May, 2025. Chief Justice Khanna will be in conversation today with William Traynor, our esteemed dean here at the Georgetown University Law Center. In addition to being the dean of the Law Center, Bill is the executive vice president of Georgetown University, and he holds the Paul Regis Dean Leadership Chair at the law school. He joined Georgetown in 2010 and was reappointed to serve a 3rd term beginning July 1, 2020. Under Bill's leadership, Georgetown has hired 75 new tenure or tenure-track faculty members, tripled the number of experiential offerings for students in its clinical, externship, and practicum programs, more than doubled financial aid, and experienced its most successful era in fundraising, culminating in nearly $67 million in giving in the last fiscal year. In 2012, he was recognized by the National Law Journal as a champion because of his work to uphold the profession's core values, and National Jurist magazine named him as one of the most influential people in legal education 5 times. Bill was elected into the Academy of Arts and Sciences for Law and Education as part of its 2020 class of new members. Most recently, he was selected for the inaugural Katzman Award for Academic Excellence. His areas of expertise include constitutional law, property law, criminal law, intellectual property, and legal history. And he was recognized as one of the 10 most cited legal history scholars in the United States by the University of Chicago Law School's Brian Leiter. Norton will publish Bill's upcoming book titled Fathers of the Constitution, Triumph, Tragedy, and the Creation of the American Republic. Before coming to Georgetown, Bill was the dean of Fordham Law School, where he began teaching in 1991. Bill holds a PhD in history from Harvard and a JD and a BA from Yale University. Last, but certainly not least, it's my pleasure to introduce the moderator of today's discussion, Vibha Datta Makija. Vibha is the true force behind the Constitutional Conversation series, along with Dean Traynor and Kashish and Asia. Vibha is a graduate of Georgetown's LLM class of 1992. She has been a distinguished or a designated senior advocate at the Supreme Court of India since 2013. Vibha was only the third woman to be designated to this position since the Supreme Court's inception in 1951. Besides being one of the leading senior advocates at the Supreme Court of India, she's a member of the Executive Committee of the Supreme Court Legal Aid Committee and a member of the Board of Examiners of the Supreme Court's Advocate on Record Committee. In 2017, Dean Traynor offered her a membership on Georgetown's Asia Law Alumni Board, and since then, her contribution to the outreach of Georgetown law in India has been tremendous. I could spend a long time listing Vibha's accomplishments, but that would leave us with little time for the conversation that she has been so central to organizing. So without further ado, let me hand the virtual mic over to Vibha Datta Makija.
Thank you, Carlos. Good evening from India and good morning in the US. And I'm very grateful to Chief Justice Sanjeev Khanna for accepting our invitation. Incidentally, today is a 1-month ceremony of Chief Justice Khanna taking over as the Chief Justice of the Indian Supreme Court. So I'm really delighted to have him here with us. And thank you, Bill, for making this possible and for being our distinguished guest as well. And just to say that it's just an honor to be here with such illustrious people. And so let's kick off this conversation. Let's see where the Indian Supreme Court is moving. Let's ask Bill what the US Supreme Court is doing at this point of time. So let me start with Chief Justice. Chief Justice, India is a huge country, and access to justice is possibly the most important thing for a citizen of this country. And the Indian Supreme Court, of course, has a very big judicial docket. But how do we bring about justice to the last mile? Is Supreme Court involved in doing that? Or do we have a system by which every citizen has to look out for themselves?
India perhaps has the most robust and unparalleled legal aid system in its scope and ambition. In 2023, Indian courts presided over 26 million cases. Now we have to provide access to justice. Now, access to justice means ease of access to justice, as well as quality of access to justice. That is quality of service. India's legal aid system is unique in several ways. Firstly, about 80% of India's 1.4 billion population is eligible for legal aid. Legal aid is a fundamental right given under the Constitution. Secondly, unlike most of the Western democracies, Indian judiciary spearheads legal aid in India. We have the National Legal Services Authority Act, under which the Supreme Court is the head institution or the authority. They are then followed by state legal services authorities, which are there in the high courts, then 700 odd authorities in different districts in the country, and about 2,500 authorities way down in the villages and talukas, the smallest. So how do we go about it? All the legal services authorities and committees are headed by a judicial officer who completely dedicates his work to these authorities. We have about 41,500 panel lawyers, 2,500 legal aid defense counsels, 8,000 pro bono lawyers who are working and providing legal aid. They go to jails, they go to courts, they go to villages. Apart from this, we have a workforce of about 43,000 paralegal volunteers. These are basically grassroots workers. These are not lawyers. They are college students, they are retired people, doctors, teachers, ASHA workers who become our voice, and they also hear and tell us their problems. The third aspect of our legal aid is we are not only not providing defense counsels, we are also providing legal aid to the victims. We are also providing witness protection. We are also looking after the families of both the accused as well as the victims. The fourth aspect of our legal aid is that we are also holding what is called Lok Adalats or people's courts. These are places where you can take the government or authorities, your grievances are raised. These are headed by judicial officers or retired judicial officers, and you get immediate justice. In the sense, your local problems or issues, small little issues, are solved and sorted out. In the last 7 years, we have dealt with in these people court about 130 billion cases or issues. Now imagine if these issues and cases had come to the court, what would have happened? I have visited villages and I find there's always a smile in the face of the villagers whenever you talk about Lok Adalat. They are very happy with the success of Lok Adalat and the relief which they get. So that's bringing justice at the doorsteps of the people. You don't have to move out, you don't have to go. We reach out to them and sort out their problems. So these are certain aspects of legal aid which perhaps nowhere in the world you will find. About 50% of appeals filed in India in criminal cases are handled by legal aid. We don't, they're virtually, I don't think Indian criminal legal system can function without legal aid and the help which we are giving.
So all prisoners under the Act, I believe all prisoners have access to free legal aid.
Correct.
And lawyers are provided free of charge
Correct.
to every convict.
Correct. We have legal aid clinics in the jails. Anybody can visit the legal aid clinic in the jail, even for second opinion. Even if you have a defense counsel, your private counsel, you can ask them for second opinion. You can ask them to help them out. We provide not only this, we also ensure that in case there's some difficulty in getting in touch with the counsel, we'll help them get in touch with the counsel.
So this network is, it's huge. Obviously, it needs finances. So where do you get the finances?
It's completely funded by the state. For example, we distributed about 3.6 million rupees as compensation to the victims in sexual assault case in last about 4 or 5 years. We are getting funding of about 40 million Indian rupees for payment to the legal aid defense councils, entirely funded by the state. The state funding has not been a problem. The state funding, in fact, they keep on asking us, please, if you ask whatever your requirements are, please ask us, we'll pay for it. So that way we have been fortunate. The state funding has never been an issue and problem.
So this idea of legal aid arose out of a very famous American judgment, Gideon versus Wainwright. And our Supreme Court noticed it in 1980s. And I believe the legislation came after the Supreme Court pronounced in Hussain Ara Khatun that every prisoner, at least, actually, I think that's where it stems from Article 21, but the expanse of the content of the right has gone out and spread out to various other marginalized sections. I believe women, even physically handicapped, mentally handicapped people. I think we are giving aid to all these people as well.
The categories which are entitled to free legal aid are very large. Almost, as I said, 80% of the Indian population is covered by it. You are right. Khatun's case was the starting point when legal aid came to forefront. But if one has to look at the Indian Supreme Court judgments, the first judgment which came about legal aid and right to free legal aid for free and fair trial was in 1951, soon after the Supreme Court was established.
I see.
We probably did not
Pay so much attention.
At that time, but in the 80s it really gained ground when the Supreme Court went to the extent of saying that it's the duty of the court to get a defense counsel appointed, to ask the accused whether he has a counsel. If he doesn't have a counsel, appoint the defense counsel for him.
That's right.
So
that's why we have a very big panel
correct,
of counsels
correct.
at every
And
level.
then the statutory or the constitutional amendments took place. The statute was made in 1987. It took about 7 years before it was implemented in 1995.
Mhm.
But now we have a very robust and a very active legal aid system. As a judge of the Delhi High Court, I found the legal aid counsels were in fact far better prepared. Being youngsters who wanted to do well in the profession, they're far better prepared compared to the private counsels. So the success rate was better in case of legal aid counsel as far as Delhi High
They were
Court is
committed.
concerned. They were very committed, very sincere. So that was whenever we'll ask for appointment of legal aid counsels, there'll be a huge number of applications.
That's right. In fact, I think we have a big time selecting panels. It's very coveted to be on the panel.
And the other thing, with the pro bono lawyers, we have about 8,000 pro bono lawyers. In the Supreme Court, all substantive sentence matters are being handled by pro bono lawyers who are appearing without charging anything.
That's right.
I think you have been also appearing in some of them.
That's right. We all contribute. So let me ask Bill this question. You just heard Chief Justice about how wide our network for affordable legal services is. Now, in America, I don't think that, I'm not too sure, I'll be happy to hear from you. Is there any statute which governs free and affordable legal aid? Because what we have heard about is, say, something like ACLU, which is a private organization, privately funded. They probably have very limited agendas, racial justice. So most pro bono work, to at least my knowledge, is limited to private organizations. Maybe some law firms may be doing some pro bono work. So is there any, how do Americans get affordable legal aid?
Well, first of all, let me just say, Viva, I'm so impressed with this series, and I just want to begin by applauding you for your vision and for making this a reality. And the Chief Justice is somebody who I admire so much, and so to be able to share this virtual stage with you is really
Thank you. Thank you. It's equally our pleasure to be interacting with all of you.
Very good. Now, and again, I think this is really part of our goal of strengthening our ties with India, as Carlos said at the very beginning, kind of the two largest democracies in the world, and I think these conversations are really invaluable. I think India has a model of providing free legal services that there's a lot for the United States to learn to, because it's a much more complete program than we have in the United States. So Viva mentioned the case of Gideon versus Wainwright, which was a Supreme Court decision in 1963. And the Supreme Court in that case said that there's a right to counsel, that everybody has a right to a lawyer, and the government has to provide that if the person can't pay for it. So that was a landmark decision, and that really changed the nature of prosecutions in this country, because at this point, everybody has a right to representation when they're prosecuted. What we don't do as well is the civil side. So there's no constitutional right to a lawyer in civil litigation, and the provisions that we have are really very incomplete. So I think Viva mentioned various cause organizations like the ACLU or the NAACP, and they perform very important work. Law firms do some pro bono representation, and that's important as well. There's a government-funded, a United States government-funded organization, legal services organization, and LSO provides free legal services on the civil side to a broad range of people, but it's limited by income. So what that means is in the United States is the people who are in the least can get free legal representation, and the people who are in the most can pay for legal representation. And the gap is what's in between. And lawyers are so expensive that, to be able to get a lawyer in landlord-tenant law or, in an immigration case is just extraordinarily expensive and out of the range for most people. So that's something that, many of us in the United States are exploring how we can address that gap, because it's a crucial gap in the access to justice area. Georgetown, working with two law firms in Washington, DLA Piper and Aaron Fox, started a program about 10 years ago that's called the Low Bono law firm. So what we do is we charge people who earn a little too much for legal services, but who can't pay for lawyers on their own. We charge them a minimal amount to represent them. And there are really two goals. One is providing those services, and the other is training people so that they are able to make a living providing services in this area. So, and we're also looking at, I think the Chief Justice is talking about paralegals and kind of very highly trained people. So we're also looking at, we as a profession are looking at, what we can do in terms of use of paralegals, use of technology in order to close the gap. But, in contrast to India, it's a very significant gap in the United States.
So your college legal aid clinics, do they contribute anything to the legal aid, providing affordable legal aid to people, or are they just, providing assistance to paid legal services?
No, so there are two specific Georgetown programs. So the DC Affordable Law Firm is a program that we have at Georgetown and University of District of Columbia, which is another DC law school. And some of our graduates provide services for minimal fees. So that's graduates. We also have at Georgetown Law, we have 19 different clinics, and they provide legal services for free. And it really runs the gamut. So it's representing juveniles, who are charged with a crime. It's representing people in misdemeanors who are charged with a crime. We have a clinic that represents people in asylum proceedings. We also have clinics that focus on international human rights and environmental law. And so actually between our clinics and the volunteer work that students and faculty do, Georgetown Law is probably the biggest pro bono entity in Washington, D.C. So we're both training lawyers, but we're also providing an extraordinary amount of free legal services.
But was this your brainchild, Bill? Let me ask you this.
Well, first of all, access to justice is very important to me. It's something that I've been very focused on during my time as dean. The DC Affordable Law Firm was a joint effort. So that was something Peter Edelman of our faculty and I and Jane Aiken and Sheldon Krantz and Mark Fleischhacker, who are two leading DC lawyers. That was a collective enterprise, and I'm really very proud of what it's achieved over the past decade. The clinics, I've been very supportive of increasing the number of clinics that we have at Georgetown to bring us up to 19. But that's something that we've historically been just, I think at the top of American law schools. But, that has been a focus of mine, increasing the opportunity for our students to do kind of hands-on learning to make a difference. So actually the opportunities for students to do pro bono hands-on work has tripled during my tenure. So this is, and I'm very proud of the movement forward that we've had during this time.
That's great service, I think, to the American people that Georgetown is doing. So let me come back to the Chief Justice and delve a little into, what our Supreme Court is, like our founding fathers have had a vision. And, it's like Martin Luther King's dream. So, and we have the longest constitution, whereas America has probably the shortest constitution. But are we staying true to the vision of our founding fathers? Are our citizens, are we expanding it? Are we limiting it? Are we just staying fixed in time? How is the Supreme Court moving in terms of actuating the rights which are guaranteed in the Constitution?
You're right, Indian Constitution is fairly lengthy. And when it was enacted, some people did criticize it. Having such a lengthy constitution will mean there's no flexibility, it's very rigid. But time has shown that's not correct.
I feel so too.
I think it's having such a detailed constitution has been very beneficial for the country. It set up certain foundational standards which are very high. As far as development, it's a living constitution, let me put it very clearly. And if there's one thing Indians are very proud of and feel very attached to, is the Indian Constitution. You just talk to any common man, any person on the street, even in the village, he holds the Constitution as important as any holy book. Constitution is for us a Bible, real sense. It's the book which helps us govern, which controls our right. As far as the rights are concerned, I think there have been 3-4 developments which are extremely important in the Indian constitutional concept, growth of Indian rights. The first is Article 14. When we enacted and adopted Article 14, we did not adopt a due process clause in the full sense of the term. Article 14 is the article which gives us right to equality, fair treatment, equal treatment. But with passage of time, all this, we expanded the scope of Article 14 to include arbitrariness, manifest arbitrariness, and doctrine of proportionality. So that helped us expand the scope of the fundamental rights. The second aspect, which was very important, is we understood right to life and liberty to include right to human dignity, to basic necessities of life. Now, when that happened, we expanded the scope to include right to food security, right to education, right to better environment, so on and so forth. One of the very interesting aspects is that many times the court decisions prompted the legislature to enact laws. This happened in the case of National Food Security Act of 2013, which got enacted after a decision of the Supreme Court in People's Union for Civil Liberties versus Union of India. Second, we enacted Article 21A, which provides mandates and provides for free legal education between the age of 16 to 14 years. This was prompted by a Supreme Court decision in Uni Krishnan's case. Thereafter, there was litigation because this Right to Education Act also provided that private schools will also have to provide 25% seats, for which the payment will be made by the government to students who cannot otherwise afford fee in those schools.
So this is free education
This
for
for-
primary level. Right.
From 6 to 14. The right of environment, again, healthy environment and pollution-free environment, again, has been pushed by the Indian Supreme Court. Of course, the government has been very active in it. They have pushed it, they have supported and have appreciated the efforts. You'll be surprised to know it was the Indian Supreme Court which directed that all diesel commercial vehicles will shift to CNG, gas, by a judicial decision, not by way of legislature or policy decision. The third aspect, which is perhaps unique to India, which not many people will be able to understand, is the PIL, public interest litigation, where the question of locus does not matter. This is a facet of right to access to justice, where people because of economic or social reasons cannot come to the court, somebody else will take up their rights. There have been issues and problems, and the areas where we normally go into are now quite fairly well defined, but this has helped us deal with several issues. I'll give you one example. NALSA, which is the head or the top of the pyramid as far as the national legal aid system is concerned, filed a writ petition in the Supreme Court for transgender rights, and they succeeded. So the legal aid has gone to that extent, the Supreme Court went to that extent.
NALSA espoused the rights of transgenders.
And then the Charter of Rights came down by the Supreme Court. NALSA, as I said, is the top of the pyramid as far as the legal aid is
So
concerned.
in fact, just to interrupt you, I was just reading on one of the news feeds, one of the cases which is recently going on, I think the judgment is reserved in one of the division benches, is whether a transgender can be deprived of employment in a government office. So I think that matter was recently heard. And
On a pending matter, I'll never say anything. But I can tell you other cases. Right to privacy, again, we incorporated it, brought into our constitution, overruling the earlier judgment, which is doubted whether there existed the right to privacy in the Indian constitution. Not only by reading it into right to life, but by also saying the fundamental rights are merely recognized by the constitution. There may be other basic rights which every human being has. Then we struck down Article 3, Section 370 with regard to consensual sexual relationship. It was a little struggle, but thereafter it got struck down, both on the ground of privacy and other right to life and other reasons. It got struck down, and now it's been decriminalized. So there have been, I think, as far as Indian Supreme Court is concerned, it's been fairly active within the contours of the Constitution, always within the bounds of the Constitution. But yes, it's a living Constitution. We are very proud of our Constitution. The heritage we got from it took about 3 years, if not more, to frame the Constitution, to adopt the Constitution. And if one has to look at the Constitutional Assembly debates, there's a TV serial on it. It's available in English also. It's eye-opener, how different views were expressed and how it was debated, and then finally we had a document.
And the American Constitution found a large amount of reference in those debates as well.
Yes. And some, I'm told, B.N. Rao was rated by some of the judges, even in America, as perhaps the
brightest of the minds.
Brightest of the mind in his time. So Dr. B.R. Ambedkar also was responsible. Come to think of it, where in the world you'll adopt universal suffrage with 18% rate of literacy at that time? Where in the world will you have affirmative action
In the
in
Constitution
itself?
itself.
We talk about substantive equality. We started the principle of substantive equality in the Constitution itself.
So in fact, interestingly, probably what race means to America is what our reservations, caste reservations, boil down to here. If in terms of affirmative action being constitutionally recognized.
I think Indian Constitution that way is far broader, far more, as far as equality, fraternity is concerned, justice is concerned. It's very deep. It specifically prohibits any discrimination on the ground of race, creed, caste, color, religion, etc.
Sex.
And also at the same time says that you can have reservation for women, children, backward castes, backward tribes. Later on, we introduced OBCs. When OBCs means other backward communities. This was reservation when it was introduced was challenged. The challenge was upheld by the Supreme Court, but with a rider. You will introduce the concept of privilegia. Privilegia means other backward castes who are well off will not get the benefit of reservation. So that was by a judicial order or direction that the concept of privilegia was introduced. Then lastly, we have brought in some reservation for the persons who are economically backward. That was also upheld by the Supreme Court. So, and we also, in this way, combine a lot of things. We have about 5-6 articles dealing with right of minorities, ethnic, religious, and so on and so forth. There's so many things which have been, probably the chapter on fundamental rights can go on and on. If you look at the Supreme Court decisions, the
I think the
legislature,
diversity of the country makes it necessary to
very much so.
acknowledge all the rights and to effectuate them.
I think this, and look at it, when we became independent, it was after a huge struggle, 200 years of colonial rule, no democracy before that, huge illiteracy, poverty, very few people who had seen how democracy works. But within 75 years, we become the front leader. We were the front runners then, as far as third world or the South Bloc is concerned. We are the front leaders today. And possibly we'll be the front leaders. We are gradually emerging as a front leader even for the developed world.
Actually, there are some solutions that probably the volumes have thrown up in this country with the kind of population that we have. So let me ask Bill.
Just one,
Sorry.
not only the population, the challenges. How do we meet the challenges? And how do we achieve success?
I see. So, Bill, let me turn to you on this. Honorable Chief Justice has just given the example of the Nalsa judgment recognizing transgender rights. So what we read and we find is that America is very proactive when it comes to LGBTQ rights, but it steps back when it comes to female autonomy, and abortion is a big issue in America. And so most of the judgments of the US Supreme Court, wherever LGBTQ rights have to be crystallized, have been progressive. But after Dobbs, we have had you've had a very big setback in terms of female autonomies. So how is this panning out in American Supreme Court?
So I think that's a very good summary of where the Supreme Court is. So Obergefell was the decision in which the Supreme Court recognized a right to same-sex marriage. And that was a huge decision, and that overturned the precedent. So really a remarkable movement forward. When I was in law school, actually, my roommate, Evan Wolfson, wrote a paper making the constitutional case for same-sex marriage. And I told him, the argument looks right, but I can't imagine the Supreme Court ever buying it. But he then went on and he became one of the leaders in the marriage movement. And in Obergefell, the Supreme Court recognized a constitutional right to same-sex marriage. Huge decision, huge decision. What we've seen at the same time is, as LGBTQ rights have been moving forward, the rights of bodily autonomy for women have been contracting. So when Chief Justice Warren Burger was Chief Justice, the Supreme Court issued a decision, Roe versus Wade, which recognized a right to choice. It was kind of a complicated three trimester focus. Basically in the first trimester, woman had control over her own body. In the second trimester, kind of a balance, and some regulations were permitted. And in the third trimester, the weighting was in favor of state regulation. So that was the framework. But then in the years after that, the Supreme Court, in a number of decisions, both upheld Roe, but at the same time chipped away. So, for example, there was a decision, Planned Parenthood versus Casey, I think 1993. I think every constitutional law scholar I knew, including myself, thought the Supreme Court was going to overturn Roe. And we were astonished when Planned Parenthood versus Casey came out in 1993, and Roe was upheld. The framework was somewhat narrowed, but the basic principle of a woman's right of autonomy over her body was upheld. What we saw in the Dobbs decision is that Roe was overturned. And that was a close decision, that there were 5 votes to overturn Roe. And but a majority of the Supreme Court said that there's no right to choose. So that was a huge decision. Again, it was 5 justices upheld that, kind of the conservative 5 justices. Chief Justice Roberts would not have gone that far. He would have basically upheld the statute issue in that case, but he would not have gone to overturn Roe. And then the 3 liberal justices, wanted to preserve Roe. So, and I think what we're seeing now is kind of at the state level, increasingly, states are taking away the right to choose at the state level. So, there again, Dobbs was concerned with the right to choose under the federal Constitution. A lot of states have kind of chipped away, and in some cases, essentially said there's no right to choose under any circumstances in their state. At the same time, when there have been ballot measures under state constitutions, there's largely been a right to choose that's been recognized. So, I think at the state level, what we're seeing is kind of the popular sentiment is actually in favor of kind of at the state level a return to Roe, but the state legislatures are often, very hostile to a woman's right to autonomy. And then transgender rights is, one of the issues that's currently before the court. There's a very important case, Griminati, in which a state essentially banned treatment of transitioning minors. And the question is whether that interferes with the constitutional right of the minors. And that was argued early this week. And I think everybody I've talked to who listened to the oral argument thinks that the Supreme Court is going to uphold the ban. So a state will be able to, constitutionally say to minors, we're not going to allow, transgender transitions, while you're a minor. So I think, overall, just to get back to your point, kind of a level of protection for LGBTQ rights, which I have to say I would never have predicted, and I think is a very good thing. Dobbs, I think, is again kind of ended a woman's right to choose, and I think that's going to be the law for the foreseeable future. And then I think that transgender rights, I think, will be kind of increasingly cut back, as the oral argument at Scriminetti suggests.
That's interesting, the case regarding the minors. So I think in the current social setting, individual bodily rights are taking the center stage because these rights are moving out of conventional molds, and there are very unconventional thought processes that are going on. So how are these going to be recognized? Are there going to be, what do you see? Is it going to be the conservative and regressive views which may hold the field for Supreme Court? Because especially taking Dobbs, considering the fact that this was not a progressive judgment, where do you think the US Supreme Court will move? In which direction will it move? Because all these challenges are going to come through, and many of them are going to be new challenges.
Right. So, and again, we have such a different approach from the Indian Supreme Court. And I thought, the Chief Justice, in kind of laying out kind of the very broad mandate of the Indian Supreme Court and the tremendous amount of cases that you're involved in, the United States is very different. The Supreme Court, our Supreme Court, decides about 60 cases a year. So just a small fraction of what you decide. But the big cases come to the Supreme Court eventually. And I think, what we're seeing is, again, I think a woman's right to choose. I think that, I think Dobbs will, Dobbs will be the case law, I think, for decades. So there are 6 Supreme Court justices who are conservative. 5 are very strongly conservative. Chief Justice Roberts is in some sense the swing vote. Within that 6 group, actually, on some issues, there's a split. So there are 3 very conservative justices, Gorsuch, Thomas, and Alito. I think Kavanaugh, Barrett, and Roberts are really kind of the swing group on the court. Chief Justice Roberts, Justice Kavanaugh, if you get any decisions that are kind of seem progressive, it's because you get at least 2 votes from that 3. And then you have 3 votes that are on the progressive side, Justice Kagan, Justice Sotomayor, and now Justice Jackson. So that's the kind of lineup of the court. I think on a woman's right of bodily autonomy, I think as cases come up, the general rule will be that will be rejected probably at the state level. And again, because you have 5 solid votes on that side. I think Obergefell will remain good law, but that's to some extent an open question. Obergefell was really a departure from precedent. The court has gotten more conservative over the past decade. On the other hand, the same-sex marriage movement has become so fundamental in the United States, so broadly accepted, that for the Supreme Court to reverse Obergefell would really be at odds with kind of popular sentiment now. Abortion, I think the court is, is probably also at odds with popular sentiment. But, I think Obergefell is something that we're seeing, the same-sex marriage is just, I think, really throughout our society has won acceptance. One of the big cultural issues that we're seeing now is legislation involving, transgender rights. And I think based on what we saw in Scriminetti, I think the Supreme Court will not be sympathetic to them as new cases come up. And I think the state statute will be upheld that's at issue in Scriminetti.
So where are we on these? So in Navtej Johar, which is the same-sex relationship matter, we stopped short of same-sex marriage. But in abortion, we seem to be allowing women to decide for themselves. Exceptions are carved out.
Yes. I ended last time by saying that certain areas you can look forward to us, and abortion rights and women autonomy and right to choice is clearly we are far ahead of others. We adopted Medical Termination of Pregnancy Act in 1971, years back, almost 30 years back. There were certain amendments then made in 2021, making it far more progressive. We now permit abortion without any intervention, court intervention, up to 20 weeks, and thereafter, in special cases, till 24 weeks. We also enacted what is called the Protection from Child from Sexual Offences POSCO Act in 2012. There were certain issues which arose because there's a read-in requirement that the medical practitioners have to inform in case they treat anybody or there's termination of pregnancy. Then the court stepped in. We introduced the right to privacy there. And when you inform, certain safeguards have to be kept. So as far as women's rights and abortion are concerned, we are perhaps way ahead in many ways.
Yes, moving strides, forward strides are being taken.
Yes, and it's happened gradually. There's been no tussle in the society as such. Society's accepted it, and the courts have also been progressive, positive.
I think that there's been, like, I remember in the same-sex marriage case, it was rejected once by the High Court. It was accepted by High Court, then rejected by Supreme Court.
No,
then they came back.
That's under Section 370.
All right, 377. Yes, right.
377. There it happened. The Article 377.
Section.
It was struck down by the High Court. There was a judgment of the Supreme Court which overturned the High Court, saying this area falls within the domain of the legislature. Then the Supreme Court reversed it after the right to privacy and said no, Section 377, criminalizing consensual sexual relationship will be unconstitutional.
That's right. So, Bill, I just wanted to ask you, because, judicial review is possibly the cornerstone of both the constitutions. But in America, it wasn't a part of your written constitution. And you seem to have done a lot of work on Marbury versus Madison. So how did this, and you were also quoted, I believe, in the Supreme Court Chief Justice Roberts' opinion. So how does America look at judicial review? Is it a part of their basic constitutional value?
So this is something I've written on quite a bit. Actually, my Carlos talked about my PhD dissertation. It's on the origins of judicial review. So the common understanding in the United States is that Marbury, which is 1803, is kind of created out of whole cloth. Alexander Bickel, who really was one of the great constitutional scholars of the 20th century, very famously said that if anything was created in an instant, any legal doctrine, it was Marbury creating judicial review. So that's kind of the common understanding. And you actually will see some Supreme Court decisions even now that say that Marbury created judicial review. And that's part of, that suggests that there's a legitimate challenge from originalist grounds, because Marbury is 1803. So it's 14 years after the Constitution is adopted, and there's no clear constitutional text creating judicial review. So some people say it's not part of the Constitution, it's not legitimate, and particularly when the court is getting more originalist, that becomes a more profound challenge. What I found in my dissertation, and it was an article that the Supreme Court cited a couple of years ago in Moore versus Harper, is that judicial review was actually very well established at the time of the Constitution. So in the period starting in 1776 until Marbury, I think there were about 30 cases in which state or federal courts either exercised the power of judicial review or said that they had the power and they chose not to exercise. And I think it's really, it's kind of inherent in the idea of a written constitution. A judge will have a written constitution and a statute, and you have to give, if there's tension, you've got to pick one or the other. And so I think what most people think in the United States is the Constitution is more important, so that's the trump card. So I think there's some people who would question that, but that's really that is kind of the well-established norm in the United States. That's part of our cultural heritage. And again, I think it's part of the original understanding. And again, that's what my work suggests. The Moore versus Harper case was a case that the court decided involving what's called the independent state legislature theory. So it was a case in which the North Carolina Supreme Court had overturned what was really a gerrymandering by the state legislature and said that that violates the North Carolina Constitution. And the independent state legislature theory, the legislature argued, under the Constitution, we determine what the rules are for elections. And the state courts can't overturn that. And that's the original understanding. So that was their argument. And I actually submitted an amicus brief, and again, the court, is really honored that Chief Justice Roberts cited me, said, no, that's not the original understanding, that judicial review was in fact part of the original understanding, and that there are no circumstances under which the state legislature can reject what a state court does when it interprets the Constitution. So that's probably the biggest, most recent case before the court, which looks at really a fundamental issue of judicial review.
Basically, the courts have to have the final word. That's the long and that according to your thesis was always the position. It didn't just spring up in Marbury versus Madison.
No, so I think that has been my position. Now, I would say that Jefferson had a very different view. First of all, he's not at the Constitutional Convention, but he has a very limited conception of judicial review, in which basically everybody, all the branches, get to say what they think, and the Supreme Court doesn't get the final word. It gets the final word in a case, but the president can take a different view and Congress can take a different view. So I think one of the things that'll be interesting to see in the second Trump administration is, does President Trump argue that in some circumstances he doesn't have to follow the Constitution as interpreted by the court. So so for example, in the Watergate tapes case, during Watergate, the Supreme Court said to President Nixon, you have to produce the tapes, and he complied. So a Jeffersonian argument, might be, well, the Supreme Court has spoken, but the president takes a different view. So we'll see if the Trump administration takes that approach. Famously, there was or at least the story of President Jackson. When the Supreme Court issued a decision that was protective of Native Americans, supposedly said, well, the Supreme Court has issued its decision, now let them enforce it. And the Supreme Court doesn't have any armies. It just requires compliance by the other branches. Historically, we've had that compliance. And my hope is that that's what we'll continue to see in the years ahead.
So when you said the Trump card, I was wondering whether that was a pun or was it intentional, or was it just as a gentle remark?
When I first wrote the article, I used the phrase Trump card for this purpose before Trump was a political figure. So I continue to use it, but as I use it, I'm very aware that it has a different meaning today than it did, 20 years ago.
Right. So judicial review is very well entrenched in our jurisprudence. But I think what actually makes justice really, something which is a complete justice is Article 142 of the Indian Constitution. And that transcends law, that transcends statute. Would you try to tell us how is that? Do you think that if the Indian Constitution didn't have Article 142, would it be, would the Supreme Court power be less effective?
I think as far as judicial review is concerned, there was never any doubt that it was vested both with the high courts and the Supreme Court as constitutional courts. That's specifically provided for in the Constitution. And if there was any debate about it, it was set to rest, saying that if you give fundamental rights, you must also give power to the courts to enforce the fundamental rights and deal with violation of fundamental rights. But what is unusual about the Indian Constitution is the power given to the Supreme Court under Article 142. That is power to pass orders to do complete justice in a given case. It's perhaps the widest power. We must realize that laws which are made are dealing with specific situations, but they cannot visualize all situations. So this is where the initial 142 power was used. But then the Indian Supreme Court expanded this power under Article 142. We virtually legislated in some cases. In one of such cases was Vishakha judgment, wherein we found there was a legal vacuum as far as offenses relating to women are concerned at workplaces. So we enacted a set of guidelines, and we said these will be enforced by different institutions. We also put a catch in it, saying that these guidelines will work or will be in operation till the legislature enacts a statute. The Vishakha guidelines continued for over, I think, about 15, 20 years.
That's right. In fact, in Supreme Court, we took
Correct.
13 years to.
Correct. So thereafter, the legislation came in. So legislation, in a way, legislature accepted the Supreme Court decision.
That's right.
And that Supreme Court decision became the foundation of the legislature. We can multiply this in several cases, but one more significant judgment, which I can talk about, 142, which perhaps I was the author, which was with regard to irretrievable breakdown of marriage under the Hindu Marriage Act. That's not a ground for divorce. Mutual consent is a ground for divorce, but irretrievable breakdown of marriage is not a ground for divorce. The Supreme Court stepped in and said that in certain cases, to do complete justice, we can pass that order. So that was a decision which came about, I think, 1.5 years back.
That's right.
And it has helped solve some matters. But we have excised power under 142 in some cases, including matters relating to custodial deaths, wherein we have issued directions how to deal with those cases. Fortunately and happily, I can say the legislature and the executive have always taken these directions in the right spirit, and they have, in fact, implemented them earnestly. We had certain amendments then carried out in our procedural courts relating to criminal law, incorporating those suggestions, in fact, going beyond them. In several cases, they even beyond them. So there has been, in a way, a fairly robust committee of, how to balance how to balance the rights. At the same time, we maintained our independence. You can, by the shears, the expanse of judgments which I have explained, the PIL jurisprudence, you can understand how active we have been as far as our fundamental rights are concerned, while interpreting them and also dealing with issues of public concern, societal concerns are concerned.
So what seems to be coming out is this, that instead of just confining your role as a body that judicially reviews executive action, you are in fact leading the executive and the legislative to make policies, laws in the correct direction.
Not always, I will not say always, but in certain cases where there is a need, there is, whenever we found that there was an issue which
Like
requires
environment or,
environment laws, we have been interfering, pushing for it. I gave some examples also. The Shaka judgment is another example. I think to some extent, the judgment, even in with regard to irretrievable breakdown of marriage, is an expansion of the law.
that's
We
right.
can say so. But on the whole, it's within the confines which are acceptable to both the legislature and the executive.
So it's not against law,
No,
but
it's
it
not.
is to effectuate rights.
It is to
otherwise.
effectuate rights and not to substitute the law.
Mhm. It's in addition to.
It is in addition to it. We could have, we have been very cautious not to overstep our jurisdiction.
I see.
Maintaining that separation of powers. We do show a degree of deference depending upon the situation of the case and the issues involved. But whenever we have to interfere, we interfere in those limited ways.
So, in contrast, I don't know, in America, social rights or equitable distribution of public resources, are the courts as interfering in this? Does the government make regulatory laws to make sure that there is an equitable distribution of the resources? I know, Bill, that you write a lot about the eminent domain. So how does social engineering work out in America? And what would be the role of courts in that, Supreme Court, US Supreme Court?
So I think the U.S. Supreme Court has a very different role than the Indian Supreme Court. So, to start, I think one of the differences between our two constitutions is that the Indian Supreme Court recognizes constitutional rights that are what we would call positive rights. So, right to education, for example. The United States Bill of Rights has been interpreted as just being really negative rights. So things that the state can't do, as opposed to things that the state must provide. And I think actually one of the things that, to go back to the right to counsel, I would question if you did not have a Gideon versus Wainwright, if that was coming before this court for the first time, I don't know that they would guarantee a right to counsel in criminal cases, because that starts to feel more like a positive right. So the court doesn't guarantee education. It doesn't. There's any kind of property, equal distribution of property. There's nothing about that in the court's case law. So again, no positive rights. In the property area, what really is, what we see is limitations on government. So this is another area that I've written about, but the Fifth Amendment of the Constitution says that if the government takes your property, it's got to pay you for it. And the original understanding was that just meant physical seizure. So you have land and the government takes it to put up a road or to put up a school. If there's physical seizure, then the government has to pay for it. But if it's a regulation that diminishes the value of your property, there's no constitutional right. So if you have, in kind of an extreme example from about 150 years ago, if you own a brewery and prohibition goes into effect, since that's a regulation, even though the brewery becomes worthless, you don't get anything from the state. But what we've seen for, at this point, 100 years, is the Supreme Court has extended the original understanding, which was just about physical seizure, to regulations. So if you have a regulation that diminishes the value of the property, at some point, the government will have to pay you for it. And one of the big, debates in constitutional laws is how far is too far. And again, that's the Supreme Court's decision in a case called Pennsylvania Coal used the language of too far. So if the regulation takes away too much value, if it goes too far, then the government has to pay you money. For many years, the Supreme Court was looking at the regulatory takings as actually a pretty limited doctrine, that there weren't a lot of regulations that were found to give rise to a compensation requirement. So, for example, in a very big case, a case called that involved Penn Central. So Penn Central is one of the great train stations in New York City. After Penn
Station.
After Penn Station was destroyed, the people who owned Grand Central Station wanted to build a big office building on top, and the City Landmark Commission said no. The Grand Central is really it's a gem, and you can't interfere with that. And that was a lot of money for the owners of Grand Central Station. They would lose the value of being able to put a skyscraper on top. And the Supreme Court said, that's okay. You've lost a lot of money, but that's not too far. You can still make a profit on Grand Central Station. So that was the big decision. But what we're starting to see now with the Roberts Court is we're starting to see a revival of the takings clause, and kind of more regulations are starting to run afoul. So we'll see what that means in the years ahead. But that is going to be, we talked about how the United States Bill of Rights doesn't provide positive rights. It limits government, and this will be, I think, an area in which the government is limited increasingly by the takings clause when it tries to do things that affect property values.
I see. That's most interesting. So before we wind up, I have one favorite question to ask the Chief Justice, which is, in this country, people really look up to the judiciary. Judiciary is the last savior. So citizens expect a lot from the judiciary. So how does judiciary keep itself accountable to the people? Because its decisions are the final stop. How are you accountable to the people of this country?
How is the judiciary accountable to the people? We are not elected. We should not be elected. We cannot go to the social media before we pronounce and say whether you're going to like this judgment or not like this judgment. That's not possible, should not be done. I think the biggest check on the judiciary comes from several instruments which are built around it. One is our training, both with regard to when should we be active, when should we restrain ourselves. Second is the bar. Because everything which is done in judiciary is transparent. It's in the open court. Our courts are open, you address arguments, you speak out, and we speak through our judgments.
And now through VC, I think everybody is watching. It's live streaming.
So VC means that everybody knows what we are doing. We're open, transparent. This is a big difference between the executive decisions and the judicial decisions. Our decision making is always tough because you have to take calls one way or the other. Most of our decisions say you are right, or you are on this aspect, you may not be right, or you are not right. We also believe, I think, what has happened in India, and I think it's to our benefit. I used to earlier debate whether we should sit in a full court while deciding most matters as the US court. But I also believe there's a big advantage in having judges from different jurisdictions who adorn the bench of the Supreme Court. They bring in their own thought processes, their own jurisprudence. And when you sit in twos and threes, they give their own opinions, sometimes at variance. We can say we are polyvocal, but at the same time, ultimately, this helps us come to the right conclusion.
And they all are not
And we
necessary.
cannot, let me put it, given the sheer volume of work, we cannot sit in a full court. Very rarely. We'll have constitutional benches. There's a big advantage in constitutional benches. The middle path comes out invariably. But there are advantages of also having benches of twos and threes. The judicial accountability is an issue which we can talk about. Largely, it depends upon the judges who are on the chair, because judges make the institution at that particular point of time.
That's wonderful. So this has been just such an invigorating conversation, and I'm so honored to have it with both of you. And you know, the whole intention behind these series is to exchange the ways we are progressing in our judicial outcomes. And I think Bill might remember correctly. I think Justice Breyer has said that even the American Supreme Court should now start looking at what the global jurisdictions are doing with their judiciary. So this has been a wonderful conversation. And I think I'll hand over to Carlos. Carlos is probably waiting to say a few words.
Actually, before we end, I just want to say what a privilege this has been for me. Viva, what fabulous questions. And we're really grappling with fundamental issues. And the Chief Justice, it really was such a privilege to hear you kind of think through the great questions that Viva was asking. So I'm really delighted that we have this series, and it was wonderful to be part of it.
I kept these words for the end. I must thank Viva Vakija, the senior advocate, for having called me. And thank you, William Trainer. Thank you, Carlos, for giving me this opportunity. It was very interesting to hear your views and understanding each other's jurisprudence and how our rights have evolved, how our judicial thinking has evolved over the years.
Over to you, Carlos.
Thank you, Chief Justice Khanna and Bill Trainer and Viva. The discussion, I agree with everyone that the discussion has been very stimulating and engaging. Before bringing the proceedings to a close, I'd like to acknowledge the contributions of several people responsible for putting this event together and making it a success. From the Indian side, and with apologies in advance for any mispronunciations, I'd like to thank Kashish and Asia, Georgetown LLM class of 2019, Jaikriti Jadeja, Aditya Sidra, Praveen Gaur, Bani Khanna, Nehal Venkateshwaran, and the LiveLaw team. And from the Georgetown side, I'd like to thank Meredith Atkinson and our team at the Dean's Office, Kyle Bernardos and our AV Tech team, Brent Futrell and our communications team, and Wilhelm Engelbrecht and our events team led by Chris Hammer. And to you, our audience, I'd like to thank you all for joining us, and I look forward to seeing all of you at our 5th annual Constitutional Law Conversation next year. Thank you.
Thank you.
Namaste.